There are four words that every single senior in America needs to know right now. Four words that could mean the difference between keeping every dollar of your Social Security, your Medicare, your SSI, or your SSDI benefits, and losing a significant portion of them forever. If you have been watching the news lately, you may have heard whispers about a major Supreme Court decision that is shaking the entire foundation of how government benefits are administered in this country. And today, we are going to break it all down for you in plain, simple language so that you know exactly what is happening, what it means for your monthly check, and most importantly, what you need to do right now to protect yourself. So stay with me through this entire video because I promise you, by the time we are done today, you will have a clear picture of where things stand and what steps you need to take. This is not the kind of update you can afford to miss. Grab a pen and some paper if you can, because you are going to want to write some of this down. Let me start by giving you a little bit of background so that everything makes sense. Over the past couple of years, there have been serious legal battles happening all across the federal court system. These battles have centered around one very important question. Does the Social Security Administration, along with other federal agencies like the Centers for Medicare and Medicaid Services, actually have the legal authority to make the rules that affect your benefits, or have they been overstepping their boundaries all along? This might sound like a technical legal argument that only lawyers care about, but trust me, it has enormous real-world consequences for every single person receiving government benefits today. The Supreme Court of the United States has now weighed in, and the ruling has changed the landscape dramatically. The four words at the center of all of this are arbitrary, capricious, or unreasonable. These are the legal words used to describe government agency actions that go too far or are not properly justified. Under the new interpretation coming out of this ruling, if the Social Security Administration or any other federal agency makes a decision about your benefits that can be described as arbitrary, capricious, or unreasonable, that decision can now be challenged more successfully than ever before in court and through the appeals process. Now, what does that mean in everyday language? It means that the government can no longer simply make up rules on the fly and apply them to your benefits without proper legal backing. For years, many seniors have been told things like, your benefits are being reduced because of this internal policy, or your claim is denied because of this guideline we follow, and most of the time, those seniors had very little recourse. They felt powerless against a massive government agency, but this Supreme Court decision, which builds on and strengthens an earlier landmark ruling related to agency power, has now given ordinary Americans, including seniors just like you, a much stronger legal shield. Let me give you a real-life example to make this crystal clear. Imagine you are 70 years old and you have been receiving Social Security retirement benefits for 5 years. One day, you get a letter from the Social Security Administration saying they have conducted a review and determined that you were overpaid by several $1,000s, and they are now going to reduce your monthly checks to recover that money. This kind of thing happens to thousands of seniors every single year. In the past, your options for fighting back were extremely limited. You could request a waiver, you could file an appeal, but the deck was stacked against you. The agency had enormous power to make these decisions and very little accountability for how they made them. Under the framework that this Supreme Court ruling reinforces and strengthens, there is now a clearer pathway to challenge those decisions. If the agency cannot clearly explain with proper legal justification why they made that decision, and if their reasoning appears arbitrary or inconsistent with the actual law, that decision becomes far more vulnerable to being overturned. This is a genuinely significant development for seniors and for anyone relying on federal benefit programs. Now, let us talk about Social Security specifically, because that is what most of our viewers care about most. The Social Security Administration manages an enormous number of programs and makes millions of decisions every year about eligibility, benefit amounts, overpayments, and more. In recent years, the SSA has faced significant criticism for some of its practices, particularly around overpayment recovery. In some cases, the agency was trying to recover overpayments that occurred not because of anything the beneficiary did wrong, but because of the agency's own administrative errors. And they were doing this aggressively, sometimes taking back 100% of a person's monthly benefit until the overpayment was fully recovered. There was massive public outcry about this, and Congress also pushed back. The SSA eventually announced some changes to its overpayment recovery policies, reducing the default withholding rate in some cases. But the underlying problem never fully went away. Many seniors are still receiving overpayment notices, still being threatened with benefit reductions, and still struggling to navigate a confusing and often overwhelming appeals process. Here is where those four words become your best protection: arbitrary, capricious, or unreasonable. If you ever receive a notice from the Social Security Administration about an overpayment, a benefit reduction, a denial of a claim, or any change to your benefits that you believe is unfair or wrong, you now have stronger legal ground to stand on when you appeal. The key is knowing your rights and using the right language when you push back. When you file an appeal or request a hearing, you want to make sure you are clearly articulating that the agency's decision lacks sufficient legal justification, that it is inconsistent with prior rulings or established policy, and that it unfairly harms you without proper basis. If you can show that the decision was not grounded in clear legal authority and was not reasonably explained, your chances of success improve dramatically in the current legal environment. Let us also talk about Medicare, because this ruling has implications there as well. Medicare beneficiaries frequently face coverage denials for procedures, treatments, medications, and hospital stays. Insurance companies administering Medicare Advantage plans and the federal government itself through traditional Medicare have enormous discretion in making these coverage decisions, and many seniors feel helpless when a claim is denied. They assume the insurance company or the government must be right, or they simply do not know how to fight back effectively. But just like with Social Security, Medicare coverage decisions that are arbitrary or not grounded in clear medical or legal reasoning are now more challengeable than they were before. If Medicare denies coverage for a procedure your doctor says you need, and if that denial cannot be justified by clear evidence-based guidelines or established legal standards, that is exactly the kind of decision that can be appealed and potentially reversed. The process starts with requesting a redetermination from Medicare, then escalating through the levels of appeal, including a hearing before an administrative law judge, and if necessary, going to federal court. Now, for those of you receiving supplemental security income, which is the SSI program, or Social Security Disability Insurance, which is SSDI, this ruling is also very important. These programs have even more complex eligibility rules and more frequent disputes about benefit amounts and eligibility than the regular retirement program. SSI recipients in particular often face very strict income and resource rules, and the SSA sometimes makes errors in calculating benefits or in determining whether a recipient remains eligible. SSDI recipients sometimes face continuing disability reviews where the agency tries to determine if they are still disabled and still qualify for benefits. In all of these situations, the legal principle at the heart of this Supreme Court ruling applies. Agency decisions must be based on clear legal authority, must be reasonably explained, and must not be arbitrary or capricious. If you are an SSI or SSDI recipient who has ever been told your benefits are changing or you no longer qualify, and you believe that decision was wrong, you have every right to appeal. And right now, the legal environment is more favorable to beneficiaries than it has been in a very long time. Let me now talk about what you should specifically do to protect yourself. The first and most important thing is to never ignore a letter from the Social Security Administration, Medicare, or any other government agency about your benefits. I know that sounds obvious, but you would be surprised how many seniors put those letters aside because they feel overwhelmed or confused by the language. Every letter from these agencies comes with deadlines. If you want to appeal a decision, You typically have 60 days from the date you receive the notice to file your appeal. If you miss that deadline, you can lose your right to appeal entirely. So please, open every piece of mail from the government, read it carefully, and if you do not understand it, get help right away. The second thing you should do is keep copies of everything. Every letter you receive from the SSA or Medicare, every form you fill out, every piece of correspondence you send, keep a copy. When you call these agencies, write down the date, the time, the name of the representative you spoke with, and a summary of what was said. This documentation can be critically important if you ever need to appeal a decision or challenge an agency action. Third, if you receive an overpayment notice or a notice of benefit reduction that you believe is wrong, do not automatically assume the agency is correct. Request a full explanation in writing of how the decision was made and what legal authority it is based on. You have the right to this information. If the explanation you receive does not make sense or does not seem to be grounded in clear legal standards, that is a signal that you may have a strong appeal. Fourth, consider reaching out for help. There are legal aid organizations in every state that specialize in helping seniors navigate benefit disputes. Many of these services are free or low cost. You can also contact your local Social Security office, your state health insurance assistance program, which helps with Medicare issues, or organizations like the National Council on Aging, which has resources specifically for seniors dealing with benefit problems. If your situation is complex or involves a large amount of money, it may also be worth consulting with an attorney who specializes in Social Security or elder law. Fifth, and this is something I really want to emphasize, stay informed. The legal landscape around government benefits is changing. This Supreme Court ruling is part of a larger ongoing conversation about the power of federal agencies and the rights of individuals. Congress is also debating various pieces of legislation that could affect Social Security, Medicare, and other programs. Things could shift again, and the more informed you are, the better prepared you will be. Now I want to address something that I know is on many of your minds. Some of you may be wondering whether this ruling could actually hurt you, not just help you. That is a fair concern, and I want to be honest with you. When the Supreme Court limits agency power, it can sometimes mean that agencies have less flexibility to do things that actually benefit recipients. For example, if an agency has been interpreting a rule generously in a way that helps seniors receive more benefits, that interpretation could also be challenged under this framework, so it is not a one-way street. The same legal tool that can help you fight unfair benefit reductions could theoretically also be used by others to challenge favorable agency interpretations. However, in practice, the most immediate and tangible impact of this ruling for individual seniors is the strengthened ability to challenge adverse decisions, decisions that hurt you, reduce your benefits, or deny your claims. And that is where the focus should be for most people watching this video today. I also want to make sure you understand that this ruling does not mean the Social Security Administration has stopped functioning or that your benefits are suddenly in jeopardy just because of this legal change. Your monthly Social Security check is still going to arrive, Medicare is still operating, SSI and SSDI are still paying benefits. What has changed is the legal framework within which disputes are resolved, and that framework has shifted in a way that gives individual beneficiaries more power in those disputes. Let me also touch on pensions for a moment, because some of you receive public or private pensions in addition to your Social Security benefits. The principles from this ruling can also apply in some situations involving pension plan disputes, particularly those involving federal pension programs or where federal regulations govern the pension plan's administration. If you have ever had a dispute with your pension provider about your benefit amount, your eligibility, or your survivor benefits, it is worth understanding that the same general principle of challenging arbitrary and unreasonable agency or plan administrator decisions may be relevant to your situation. The bottom line is this: you have more power than you may realize. The system can feel overwhelming and one-sided, I know that. When you get a letter in the mail saying your benefits are being reduced or your claim has been denied, it can feel like the decision is final and there is nothing you can do. But that is simply not true. And this Supreme Court ruling reinforces that truth in a very powerful way. You have the right to appeal. You have the right to a fair hearing. You have the right to demand that the government explain its decisions in a way that is grounded in law. And now, the legal backing for those rights is stronger than ever. So please, take this seriously. Share this video with your family members, your friends, your neighbors, anyone you know who receives Social Security, Medicare, SSI, SSDI, or any other federal benefit. Because this information could genuinely make a difference in someone's life. A lot of seniors lose benefits they are entitled to simply because they do not know their rights or they give up when they face the first obstacle. You do not have to be one of those people. If you found this video helpful, please take a moment to give it a thumbs up. It helps us reach more seniors who need this information, and it lets us know that you want to see more content like this. And if you have not already subscribed to Senior Benefit Scope USA, please do that right now and make sure you have hit the bell icon so that you get notified every time we upload a new video. We post updates every single day on Social Security, Medicare, SSI, SSDI, pensions, and all the government programs that matter most to seniors and their families. If you have a question about your specific situation, leave it in the comments below. We read every comment and we do our best to address your questions in future videos. You are not alone in navigating this system, and we are here to help you every step of the way. Thank you so much for watching, and we will see you in the next video.